relationships in the past, which have caused complete destruction for her. She's lost custody of her children. It's caused.
With regards to drug use, honesty is always the best policy. All right. Good luck to you. Court is calling 2023 CR 3442 State versus Robin Huerta Hernandez. Can I have parties announced for the record for the state? Defense.
This is Pauline Portillo for Miss Robin Huerta Hernandez.
And are you Miss Hernandez?
Yes, sir.
All right, and you need to slide over a little bit so that the state will have room. All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes,
Are you the same Robin Huerta Hernandez who was placed on deferred adjudication in 2023 CR 3442 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on August 17, 2023 for a period of 2 years? Is that you?
sir.
All right, state.
Your Honor, we wish to proceed on violation of condition number 4 in Bexar County, Texas. The defendant, Robin Huerta Hernandez, did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, and September 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We waive and abandon the remainders.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? You need to
Yes,
speak.
yes, yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4? All right, so here's the thing. Let me explain this to you. You've entered a plea of true to violation of condition number 4. Maybe you and your attorney have worked out an agreement with the state. I don't have to follow that agreement. The reason why I don't have to follow that agreement is because you don't have a contract with the state or with your attorney. The contract is with the court, and that contract is your conditions of probation. So by pleading true to violation of condition number 4, I don't have to follow any agreement that has been reached between you and the state. It's just a recommendation, right? So you're looking up, I could revoke you and sentence you to 2 years. I could send you up to 10 years and I can sentence you up to $10,000 fine. Do you understand? Knowing that, do you still wish to plead true to violation of condition number 4? All right, do you want to step back and talk to her some more?
No, no, no,
Yes.
no, yeah, I think-
Okay, yes, Your Honor.
Sure. All right, and you're Miss Hernandez? All right, so you had entered a plea of true to violation of condition number 4. The court explained to you what the implications of the plea of true. And I gave you time to confer with your counsel. So do you still wish to plead true to violation of condition number 4? Do you understand by pleading true to that violation, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? And is there a proposed agreement?
Judge, so there's not really an agreement, each side's asking for something different. As far as the state and what the state is asking for, we are asking that you deny the motion. However, we are asking for you to alter and amend her condition. We'll continue her on deferred, but alter and amend her conditions for a 1-year extension and order her to go to safety due to the struggles that she has had with reporting and failing to submit to her doings.
All right, defense, what are you requesting?
Judge, we're asking for the extension of the 1 year as well, but instead of safety, we're asking for some form of supportive outpatient treatment. Since Miss Huerta Hernandez was released, she's been doing almost daily NA meetings online. She's been checking in with Miss Lanier, her pretrial supervision officer, which I have an email from her in Defendant's Exhibit 1 that she's been in full compliance, no violations on her GPS.
Any
I
objection
have
to?
a chance to review it. I have no objection.
All right, I'll review that.
And the MTR alleges drug use in February, but there have been no positive tests since then. I do intend to call Mr. Mike Hernandez, her fiance, and Miss Hernandez herself to explain the non-reporting. I urge the court, if they're between making a decision between SafeP and what I'm asking for, which is a supportive outpatient program, that they send Ms. Huerta Hernandez for drug testing. I do believe she's going to come up negative. And I do believe that I'm gonna put on some evidence.
So why hasn't she been reporting?
Judge, it seems like around the time that she stopped reporting in March, she was dealing with some homelessness. And she recently connected with her fiance, and she's now living with him, which was not a circumstance back when she stopped reporting. He's been keeping her on track, helping her to get clean, helping her to look for employment. She has been a victim of abusive relationships in the past, which have caused complete destruction for her. She's lost custody of her children. It's caused drug use. It's led to a diagnosis of bipolar disorder and depression. And so at this point, I think she is in the best position with the support of her fiance, with the support of her fiance's mother, who have been waiting here all day for her. And I think she's just right on track, Your Honor, to not relapse again. She's been doing everything she's supposed to do. She's she also has some medical disorders that I think are gonna cause a problem for her if she had to go back into detention. She has a little eye infection, if the court could take notice of. She has a cut eye that I think she needs to get treated pretty soon, and she has asthma that she said was very difficult for her when she was in SATIF. And Your Honor, I think just the circumstances for her right now are gonna be optimal for her to succeed and not relapse. She has no criminal history besides this case. So at this point, I'm asking you, add conditions, weekly UAs, random UAs, zero tolerance, can keep her on GPS. She would like to look for work as a housekeeper at this point to help contribute to the household and get some visits back in. She has ordered supervised visits through Guardian House right now with her 16-year-old. So she really just wants to get her life back together and get back on
I'm
track.
sorry, what did you say about her and a 16-year-old?
She's supervised visits at Guardian House right now. They cost quite a bit of money though, so she will have to work to try to get those visits in. But that's my understanding from what she tells me is going on with that minor child. She does have older children as well. They're adults. They were here at the last setting, but as far as just the minor, she really has to rebuild that back up because her past relationships have really caused havoc in her life
Okay,
and have led to these behaviors.
and state.
Judge, I am in agreement. This is her first MTR. She doesn't have any additional criminal history other than this. However, she has had some issues reporting, and I just think she needs a more structured environment to really help her if she's really serious about getting clean. She did complete SATIF, but did struggle in aftercare, and then just kind of falls off the grid, absconded from the jurisdiction of the court. And there haven't been any positives because she hasn't submitted to UA. And so that's why I'm asking for what I'm asking for, Your Honor.
And Judge, I meant to tender Defendant's Exhibit 2 also, which is the verification that she's been attending the NA meeting.
Mhm.
Mission and published to the court.
Yes. If you drug tested today, what are the results going to be?
Negative.
All right, you're going to go do a drug test today. Bashan, she's going to go do a drug test with felony drug court. So if you could have her go, and I'm going to send you some information of who to contact, and they're going to want a photo ID. So if someone can, do you have a photo ID?
I don't, Your Honor.
Oh, they can take a photo, somebody take a picture of her and give it to them. Just send it. All right, we're gonna come back with this. And she's in custody because she's late, correct? And you're on GPS and you're late. Why were you late?
There was a long line outside, Your Honor, to get in on the courthouse. I was
All right,
here.
So deputy, what we'll do is we're gonna release her so she can go and do her UA. All right?
Judge, will she be brought back here today? So should I just go ahead and
Oh,
wait?
no. Yes, wait. She's gonna go straight over there and she's gonna come straight back. Her fiance is here. I'm sure he can drive her.
Yeah, sounds good.
Okay.
Oh, I'm sorry, but her counsel, I should wait, right?
Yes.
For her to come back. Okay.
And if you speak to Miss Abrams, she'll tell you where you need to go. Oh, and counsel, your exhibit you wanted me to review?
Thank you.
Thank you. All right, and this is State of Texas versus Robin Huerta Hernandez. You entered a plea to violation of condition number 4. You entered a plea of true. The court ordered a UA, and you informed the court that you would be negative. I'm sorry?
Want to do that, and I oriented to me, and asked for you to see these, and I do want to change. I am changing. I have changed. People have places and things. I do have support now, family support, and nobody knew. I thought it was quick about me, and I'm sorry for lying. I do want to change, but I thought and I am.
All right. All right, is there anything else from the state or the defense?
Nothing.
All right, you've been missing for many months. That's what your plea of true was. I was informed that you were going to be clean, that you've been doing great work, but you were not clean. The court is going to grant the motion. The court is going to find you guilty. The court will revoke, request the therapeutic community. How much time are you asking for, state? Defense, what are you asking for? All right. The court will sentence you to 3 years in the prison, give you credit for any time served, and the court will retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. I will tell you in this court, with regards to drug use, honesty is always the best policy. All right, good luck to you.
This case takes a dramatic and heartbreaking turn the moment the judge lays out Tina Kaufman's history, because what we're watching isn't just a standard probation review. It's a clear pattern of repeated danger, escalating risk, and a person who simply cannot keep herself or the public safe. And the most alarming part? She drove to court today while still legally intoxicated. Think about that for a second. This is the one place where you want to show the judge you're following the rules, that you're improving, that you're taking sobriety seriously. Yet she shows up with a breath test of 0.87 at 9:40 a.m. That number alone sets the tone, but the deeper issue is everything that led up to this moment. Let's break it down clearly. Tina had already been arrested multiple times for drunk driving, May 26th, August 7th, and then again in Indiana on June 19th. One of those arrests even had a 0.294 BAC, which is close to 4 times the legal limit. That is not casual drinking. That is life-threatening intoxication. Yet despite that, she was given a huge opportunity. The court dismissed one case entirely and gave her probation under the hope she'd succeed in sobriety court. But when she moved to another state, that option disappeared. And instead of using traditional probation responsibly, she slid right back into the same dangerous cycle. The judge calls this exactly what it is: a serious substance abuse disorder paired with repeated drunk driving while on bond and probation. That combination is lethal. And notice how the judge keeps using the word danger, not as drama, but as a legal and factual assessment. Tina's pattern shows she can't remain sober, she continues to drive, and she refuses to follow the most basic requirement: taking tests when asked. There's also a critical legal reason why the judge immediately halted the hearing. She's legally intoxicated right now. A defendant cannot meaningfully participate in their own hearing or make a clear record when impaired. So even if he wanted to dig deeper or discuss options, the law itself limits what can happen today. That's why he orders custody, a contempt finding, a probation violation, and a next-day continuation once she's sober. Another important moment is when the judge warns the jail about potential withdrawal issues. This is not a judge being harsh, it's a judge being responsible. When someone drinks heavily and then suddenly stops, withdrawals can be medically dangerous. He's not only thinking about public safety, he's thinking about her safety as well. Then comes the emotional moment when he asks if she has pets and tells her to find someone to take care of them. That's the reality hitting. Jail is happening immediately. This isn't speculation. This is consequences catching up. Finally, the judge announces a new criminal investigation for driving to court intoxicated. That alone could result in another charge, and potentially another probation or license violation. It's a tragic spiral, and the judge knows it. His last line sums everything up. You're going to kill somebody or yourself or both. That's not anger. That's reality. So now I want to ask you, the viewers, do you think the judge handled this the right way? Should probation have been revoked sooner? Or did she receive more chances than most people would? And what would you do if someone in your life struggled with this level of addiction and risk? This case is a heavy reminder that courtroom decisions aren't just paperwork. They're attempts to prevent tragedies before they happen. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.